Welcome to the Republican Professor. I'm my own host, Dr. Lucas J. Mather. I'm the host of the Republican Professor podcast. We have been ranked the worst podcast by Hell magazine in their July 2023 edition. We are ranked as mediocre by several of Purgatory's newspapers. And I have an ad. We got to pay the bills, so please just you know, hang with me for this very short ad. Have you ever wanted to buy something? Go to a store. There are lots of stores all around. Uh, we recommend that you go in there even if you don't feel like buying something and buy something. Use code store 10 Republican Professor 2025 for a coupon to pay an additional 10% that you wouldn't otherwise have paid. Go to a store and buy something today. Thanks for hanging with me for that wonderful ad. We couldn't do it without sponsors like a store. So please go out and buy something. And don't forget the coupon. You can pay a little bit extra if you want with that coupon. We are in Duncan versus Bonta. This is about the standard capacity magazine ban that was upheld by the banc Ninth Circuit. It's a bad decision, and we have some Republican judges in dissent. We have covered Bumate's decision in dissent quite in detail, and today we're starting with Van Dyke's dissent. And what's notable about Judge Van Dyke's dissent, he's a Trump appointee, just like Bumate was Republican judge on the Ninth Circuit. What's notable, though, is the fact that he used a video as part of his dissent. And this is what has people talking. Catch this. You have a Ninth Circuit judge in his like regalia, in his chambers, okay, with his own guns, and and he's using them as props in an official Ninth Circuit publication. By the way, there's no copyright on these. There's no copyright on the videos. It's in the public domain. So the government doesn't own it. It's out there. You can, we have permission to use clips of the video because there's no copyright on these decisions that they write, and this video is part of the decision. You'll see. How did I get here? Well, just you can Google Duncan versus Bonta Ninth Circuit, go to the Ninth Circuit's website, and you can get there. That's where I'm at, and it's a PDF that you can click on. If you are not sure if you're getting the right one, this one was published the year 2025 in the month of March on the 20th. I believe it's the 20th. Yep. And you can see the web address right there. So, um, yeah, it comes up. I don't like the AI, but it's right here. And you can go right to the decision. Now, and there's the date right there. This has been up and down, okay, in the courts. But Van Dyke is, it's he's controversial. I think it's safe to say that he's controversial. Of course, any Republican is controversial. Like if you're a Republican professor, you're controversial, you know. Uh, I like this guy, but I can tell that people don't quite know how to react to the fact that he used his judicial discretion to whip out his own guns in chambers and video it. and put it on the official website of the Ninth Circuit. Not kidding you. Not kidding you. I mean, we'll get there. We'll get there. I'll show you the video on YouTube. And people on YouTube, this is not copyrighted material. Okay, this is in the public domain. So we are using it fairly. And of course, this is a fair use and a transformative reading anyway, but there's no copyright to be enforced here. So um, that's a wonderful thing about reading decisions on here is first of all, they're published for you, for the public to learn. That's why they're published. Guys, you guys know that, right? You see that on the top of this page, if you just go to page 1, it says for publication, but there's no copyright on this. You can search all day long. You're not going to see any copyright. Now, if you go to page 123, you'll see Van Dyke Circuit Judge dissenting 3 years ago. The Supreme Court vacated our court's opinion in this very case, presumably because we tried the same tack that Bruin rejected in no uncertain terms. Engaging in interest balancing after assuming that an activity falls within the scope of the Second Amendment. This is a very strong opening here. Very strong. I highly recommend you print it out, by the way. Print out these suckers. Keep copies of them. You guys, seriously, you got to get yourself off screens. Do whatever it takes to get yourself off a screen. Okay. I was in court all day today. Now it was a basketball court, but trust me, you want to get yourself off screens. Okay. Print it out. Now, the ironic thing about what I just said is I'm on a screen, you're watching this on a screen, but close your eyes if you have to, or print it out and just listen as we go through, because you might feel like you're not confident in learning this stuff. You can learn a lot. You guys, you can learn a lot by reading judicial opinions. And I only give you the best. I only give you the best here. Not going to waste your time. You can learn a lot of American history. You can learn a lot of policy. Just reading not only Supreme Court decisions, but important decisions at all levels. And we've done all levels. We've done district court, we've done the circuit or the appellate division, and we've also done Supreme Court decisions here. All right, so we got a strong opening here. In other words, our court's reliance on interest balancing, like the Second Circuit's decision in Bruin, took one step too many. Yeah. Yes, brother, you preach it. 3 years ago, the Supreme Court vacated our court's opinion in this very case. Presumably because we tried the same tack that Bruin rejected in no uncertain terms, engaging in interest balancing. Bumate was saying that. After assuming that an activity falls within the scope of the Second Amendment. You can't do that. In other words, our court's reliance on interest balancing, like the Second Circuit's decision in Bruin, took one step too many. Because, as the Supreme Court made clear enough in District of Columbia versus Heller, Second Amendment is itself the very product of an interest balancing by the people. It is not our role to conduct it for them anew. This is a very strong opening here. I love the quotation from Heller, 2008. Judge Kavanaugh, when he was on the DC Circuit in Heller 2, 2011, he was writing in dissent. He used that same quote. He said, "We are not supposed to be doing interest balancing. Now, that was before Bruin. That was before he was on the Supreme Court. So Van Dyke has this exactly right. Judge Kavanaugh himself, when he was a judge on the DC Circuit, an appellate judge, he got it. He's like, yeah, when I read Heller, it's a basic decision. Interest balancing is at the founding. It's not with us. The founders, when they ratified the Second Amendment, did the interest balancing. They already figured that out. We're not supposed to be doing that again. We're not relitigating whether there should be a Second Amendment. Notwithstanding these repeated directives to stop. Today's decision doubles down on this court's prior practice of balancing away the rights of law-abiding citizens to bear arms in self-defense, only this time under another name, rather than balancing after concluding that the original understanding of the Second Amendment protects an individual's conduct. The majority now merges its balancing into its determination of whether the Second Amendment protects an individual conduct at all. Wow. Wow, 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 wow. That is such good writing. This reinforces why interest balancing must have no place in applying the Second Amendment. Yeah. Mhm. I wholeheartedly agree with Judge Bumate's excellent dissent. Now, okay, let me just say this. Judge Bumate did not join his dissent, though. He's writing alone. Why is that? I have a theory about that. Stay tuned. Or don't stay tuned, and then you'll miss it. But I enjoy having the theory, whether you learn about it or not. I'm going to share it. So feel free to hang out if you want to hear it. I think I'm right. I think I'm right. You can tell me if you think I'm right. I'm happy to hear. I love the conversation. I wholeheartedly agree with Judge Bumate's excellent dissent. Another Trump appointee. See prior YouTube videos that I've done here, which thoroughly demonstrates the correct approach under the Second Amendment following Bruin. I write separately but equally to further highlight some serious flaws in the majority's analysis. If some of what you read below sounds familiar, it's because consistent with the majority's reuse of balancing by another name. Now, when he says the majority, he means in this case in the Ninth Circuit en banc, the Democrats, in other words. He's not saying the Supreme Court. He's saying this one. He's writing in dissent. And some of what you read below sounds familiar is because consistent with the majority's reuse of balancing by another name, many of the flaws I identify are barely disguised retreads of those I pointed out in our last iteration of this case. Notwithstanding Bruin, very little has changed about the Second Amendment out here in the Ninth Circuit. Okay, this is a very strong opening. Now we're on Roman numeral 1. We're on page 124. This is where why is he writing alone? Why is nobody joining him? Because you got Bumate, he agrees with Bumate. You got Nelson, right? Um, Nelson was writing. Let's look at Nelson really quick. Um, I recall liking Nelson's. Um, hmm, yeah. Let me just find Nelson really quick. There we go. Okay, Ryan Nelson, I believe, is a Republican. Okay, here's his. His is on page 73. It's very short. He says, I agree with Judge Bumate. Notice he doesn't say any, I don't think he says anything about Van Dyke. Yeah, it's very, and then he joins Nelson along with Ikuda. So there's 4 people joining Bumate. Bumate's the popular kid. Van Dyke's on his own, but I think you tell me. I, I think he might have the best dissent, and he's writing alone. Why is that? I I'm going to tell you. I'm going to tell you, but let's first look at Judge Nelson's first, real quick. So it's only two paragraphs. I agree with Judge Bumate that the majority's decision to reverse district court on the merits flouts New York State Rifle and Pistol Association versus Bruin 2022. But the majority didn't just butcher the Second Amendment and give judicial middle finger to the Supreme Court. See, that's okay. I remember liking this. Yeah, that's good stuff. I have it printed out, but I'm going to for just quickly read it here. Um, I'm disobeying my own anti-screen scourges, but I got to use this to some extent to get people off screens. Maybe we can all join a phone call at some point, but I don't think that's going to happen anytime soon. It also spurns statutory procedure for en banc proceedings. As explained in my dissent from the order filed concurrently with this opinion, this en banc court lacks statutory jurisdiction to decide this new appeal years after it remanded the prior appeal to the district court. That might be something that the Supreme Court looks at right there. That might be by itself something the Supreme Court would be interested in, especially if they're being squirrely about the Second Amendment now. See, this is a procedural issue. And if there's anybody that's being squirrely about the Second Amendment on the Supreme Court, they might not want to be squirrely about the procedural issues, the jurisdictional issues, because that would be a statutory, not a constitutional question. And whenever the court can go to a statutory construction rather than constitutional, they tend to like to do that because um, it's less momentous, I guess. Page 74, we're still on Nelson. We got one paragraph left. Every other circuit applies Section 46C so that's part of a statute, to require a new en banc vote in a new appeal. As Judge Ikuda points out, the majority's view is not the best interpretation of this statute in light of the history and purpose of an en banc consideration. Nor is the majority's retention of this case business as usual. Never before, okay, whenever I hear a judge say never before, I'm going to pay really close attention here, what he's saying. Never before has a court allowed 5 senior judges to control an en banc decision on behalf of the court's active judges. Now, this is getting a little bit inside baseball here. And we might not like the answer that the Supreme Court gives to this if they take it, because what they might do is they might not decide the constitutional question. And then we're going to all be like, just come on, seriously, so that we can get rid of these magazine bans. Seriously. They might just go, yeah, you can't have 5 senior judges controlling an en banc. What is a senior judge? A senior judge, they're not supposed to be controlling the precedent of the circuit. They've retired. It's considered inappropriate. And what this guy Nelson is saying is this is illegal. You can't have retired judges. Now they're senior. So what that means is basically they can show up if they want to. Like they can take a case. Once they're on a case, they are now obligated, but they can basically show up to work whenever they want. They don't have to, they get paid the same, but they could work 10 hours a week if they want, as opposed to 50 or 60. Um, they don't have to work at all if they don't want to. But the idea of having a senior status is so that it's not a cut and dry thing, whether you're retired or not. You can still hit the golf course and you can still don the robes and be active in helping the backlog of cases get through. So it helps the circuit, takes the work pressure off of them, the active judges. But the active judges, that is to say, the ones that are not retired, those ones are supposed to be the ones setting the precedent for the future, not the retired ones. That's a long version of what he's saying here. We shouldn't have been the first, let alone in such an important case. As Judge Bumate notes, the majority's decision was a misuse even of our own rules. The result is a precedential Second Amendment opinion that largely reflects the views of 5 senior judges, not the active judges statutorily entrusted with interpreting or determining the major doctrinal trends of the future of the court. That does not bode well for public confidence in the courts and our court specifically. I mean, it's an interesting concurrence. I think this might be I'm sorry, not concurrence, dissent. This might be the dissent that gets the Supreme Court's attention. I'm sorry to say that. I don't want to be the one to say that, but mm. So it might be that if the court is being squirrely, the high court, they they accept the other non Second Amendment areas. That's what they're going to focus on. And then you'll get some concurrences that are pretty strongly worded about how the Second Amendment also protects um, magazines that hold 11 bullets or more. You know, actually, it doesn't protect the magazine, it protects the people who own the magazine from prosecution for criminal uh, against wrongly enacted criminal codes. Okay. Now, I'm going to go back down to page 123, where we were, 124, Van Dyke's. All right. Roman numeral 1. The majority begins with Bruin's cue to first determine whether the Second Amendment's plain text covers an individual's conduct. One might expect this to be a mechanical or routine part of the analysis, especially considering the Supreme Court's emphasis that there's only one step in assessing a Second Amendment claim. But many courts, like ours, have instead taken Bruin's guidance to mean there is an extensive first step, arm or not inquiry. According to the majority, California is correct that a larger capacity magazine is not an arm within the meaning of the Second Amendment because it is an accessory or accoutrement, not an arm in itself. As a result, the majority concludes the Constitution does not presumptively protect it. Did you catch that? Did you catch that? But whether a firearm component is an inherent and necessary part of the arm itself, or instead merely an optional and unnecessary accessory to the arm, is a hopelessly indeterminable and inadministrable distinction. As is true for almost any type of object, from cars to computers to sewing machines to software, there is no Platonic ideal of a firearm from which such distinctions between inherent and optional parts can be objectively derived. Now, I think this is the heart of what he's saying here. He's saying this is a reductio ad absurdum type of argument. Do you know what a reductio ad absurdum kind of argument is? How many of you know what a reductio ad absurdum argument is? Keep both hands down if you know what a reductio ad absurdum argument is. Everybody? Okay, good. Let's see here. I've got a rule book for arguments. You could look it up in this. Arguments by analogy, arguments by example, arguments about causes from authority, deductive arguments. Reductio ad absurdum is under deductive, at least in this one. Um, the form of a reductio ad absurdum is as follows, according to Anthony Weston on his page 55. One traditional deductive strategy deserves special mention, though strictly speaking, it's only a version of modus tollens. Sit there and look bored if you know what modus tollens is. Okay, everybody? Okay, good. This is the reductio ad absurdum. It's a reduction to absurdity to prove P. Assume not P, that is, that P is false. From the assumption, derive an implication, Q. Show that Q is false, contradictory, silly, absurd. Then you can conclude P. Arguments by reductio, as these arguments are often called, thus establish their conclusions by showing that the denial of the conclusion leads to absurdity. There is nothing left to do, the argument suggests, but to accept the conclusion. Now, I think that's very, that's well and good. It gives you an idea, flavor for what it would look like in a deductive argument. But a reductio ad absurdum, you could just describe it the following way: that if you take the premises, they lead to an absurd result. You're then obligated. It's not optional. You are left with an absurd result. So the under the assumption that reality is not absurd, which maybe you're thinking that's actually a controversial assumption there. But under the assumption that that can't possibly be a description of reality, in other words, your conclusion is supposed to be what reality is, right? You're concluding something about reality. So, but if that's absurd, then you must go back and find the mistake. It must be a problem with one or more of the premises. Okay, assuming that the reasoning follows. So if it's a if it's an inductive argument and given these premises, let's say it's a strong argument, the conclusion is likely to be true given those premises. Well, if the likely conclusion is absurd, there's a problem somewhere, right? Got to go back. Go back to the premises and find out what the problem is. And that's assuming you're reasoning correctly. But if there's if you're reasoning correctly, and don't get me started on induction. I know it's a quagmire. I understand, lots of ink has been spilled on induction. uh, what counts as induction and all that. But he's saying that the if you take the correct the assumptions that they're making, the premises, and you reason correctly from them, you get an absurd result. So there must be a problem up there. And one would wonder why the majority didn't see the absurdity, right? Why do they need it to be pointed out? Well, um, let's keep going. I'm not sure if that helps or not, but you could get a rule book for arguments. It's not bad. I mean, I wouldn't they're just tools, people. They're just tools. You can use any logic book. I like Patrick Hurley's A Concise Introduction to Logic. I like Irving Copey's Introduction to Logic. That was my textbook when I went through. Um, you can, there's a logic book. There's Kahani and Tidman's Philosophy and Logic, I think it's called. My name is in there as one of the reviewers. Um, that's a good one. It's got great truth table, truth tree stuff, truth trees. It's got really helpful truth tree stuff, I think. The logic book was pretty good too. But those are very technical books, and something that's a little bit more accessible. Maybe there's, well, here's one. The Philosopher's Toolkit by Stephen Scott Aspenson. You could check this out. This is pretty helpful. This this has a lot of philosophy in it, but it connects with logic. Almost everything in here connects with basic logic. It's basically a glossary with explanations. And Richard Fumerton blurbed it. That might not mean anything to you, but Richard Fumerton is, I think he's a pretty decent epistemologist. And anytime a decent epistemologist blurbs a book, I pay attention. So, hey, let's get back to this, all right? Enough about philosophy, okay? Let's keep going here. Epistemology. I'm going to have to put this in my basic metaphysics and epistemology playlist because we talked about basic epistemology here. Yet, the majority relies on its invented arms accessory distinction. We're back on Van Dyke on page 124 as an on-off switch for fundamental constitutional protections. Because that distinction has no basis in reason or reality. Okay, there you go. Okay, good. What this new test is really cover for is the majority's ipse dixit. A higher capacity magazine is an accessory and thus unprotected by the Second Amendment because the majority says so. And a lower capacity magazine, now pay attention to this is the reduction to absurdity. We've just said a magazine is not an arm. It's an accessory. Okay. It would seem like that would be any magazine. It wouldn't have anything to do with the capacity of that magazine. Well, okay, so the majority basically is stipulating that. They're not proving it, they're stipulating it. Okay. Or maybe they're inferring it from premises about those things that are essential to firearm operation versus not essential or something like that. Okay. And a lower capacity magazine, as yet unidentified, is a necessary part of the arm. That's absurd. A magazine cannot be at the same time and in the same respect, qua magazine, an essential feature of a firearm and not an arm at all. That doesn't make any sense. That's absurd. Okay. And a magazine qua magazine as a magazine, and you might say quae, who knows how to say these Latin words? I mean, it's not like we have the CDs that were unearthed in Pompeii excavations and we play the CD, or it's an eight track and then that's the pronunciation we now know. Who knows how these are, but A magazine, Quay magazine or Qua magazine, is either part of the firearm or it's not. It's an accessory. So which one do you choose? Well, what Van Dyke is saying is you can't say both. You can't say both. And the only way you get to both is if 11 plus bullets is bad and 10 or less is good in terms of the criminal law. 11 plus criminal offense, 10 and below, you're a Eagle Scout, model citizen. Hmm, interesting. Yeah. Um, this is a terribly unprincipled way to analyze constitutional rights. I mean, this has the understatement of the year award goes to Judge Van Dyke on the Ninth Circuit. Congratulations. I can't believe I won. Yeah, let's give your acceptance speech. Yeah, whoa. Is this thing on? Is this thing on? I want to thank the Ninth Circuit for this wonderful understatement of the year award. It's the last sentence of the top paragraph on page 125. I appreciate it so much. I'm going to go back. Initially, I planned to explain my reasonings for dissenting on this conceptual point, though, through usual judicial means alone. Okay, now this is where I think this is where people didn't want to sign on. He's like, initially, I was just going to write this out. That's what he mean by usual judicial means alone. But what Van Dyke means is he's over there writing this, he's typing this, and he's thinking about his own gun collection. And he's like, I'm gonna get some guns out. And that's what he does on camera in his own chambers. Oh my gosh, this is and I think the Ninth Circuit video, it basically went viral, and the Ninth Circuit's not used to that. I was going to do usual judicial means alone. um, describing in writing, see, he's priming you for this, some real world illustrations to explain how the majority's supposed armed distinction collapses. But at argument, it became clear to me that a visual illustration would greatly aid my colleagues and the parties in better grasping how this rather obvious conceptual problem specifically applies to firearms. Here's where I'm going to tell you why he didn't get people signing on to this. One, judges typically like to go with tradition. It's a very traditional job, traditional building, traditional garb, this and that, right? Two, it's firearms are heavily regulated, and anytime you bring a firearm into chambers, um, I think people don't know what to do with that. Is this evidence? Is this what is this? Are you submitting new evidence for this? Like that's not part of the record? These are your firearms. So what's Kramer, what's going on here? And I think guns just in general make people feel squirmy and squishy, and they don't know what to do with a judge up there. I mean, maybe a lawyer in court, talking to the jury or whatever, presenting evidence will have a firearm. It's part of evidence. But to have the judge himself do it on camera and he's like filming himself on his own iPhone or who knows what kind of camera he had. I think people just they don't know what's going on. They don't know, is this appropriate? Are you supposed to do this? It would be like if there was a case about construction or something like that, and and the judge had his own backhoe, and he's on his, his he's like, here, let me show you what I'm talking about. And he's like, gets on this tractor and he's like, see, and this is my tractor and this is how it works, and he's like, driving over a car or something, and you would be like, this is entertaining, but this guy is kind of crazy. I think that people think he's crazy. Of course, all the anti-gun people, the Democrats are like freaking out, like they already think he's crazy, but this only proved that to them. But then again, he's a sitting judge and he's got life tenure, and so what do? I mean, you can't fire him. So you have to listen to him. And all of a sudden, he publishes it on an official government YouTube channel, and the sucker goes viral. And the Supreme Court is watching that. Of course they are. All the clerks are, because it's the talk of the town. So Van Dyke definitely got attention, and it wouldn't surprise me if the Supreme Court took this case, not admitting that that's why, but in part because it's on their radar. This was the one with the video with the judge and his guns. you know, it's I think that these other judges agree with him maybe, but they weren't sure, so they didn't join. There's another possibility, and the other possibility is that they just don't know about guns. They don't understand how they work. Um, they maybe are following him, but they're not sure about how guns work. And um, Van Dyke is saying, look, anybody who understands firearms will immediately understand what I'm saying. And obviously, you knuckleheads aren't getting it. You're missing, with all this evidence, you're still not getting it because you really don't understand firearms. And that's kind of the problem. There's not enough background knowledge in the record, because there's what's in the record, but if you don't have the proper background knowledge, you can't interpret what's in the record. You know, you can't just take it for granted that people have this background with firearms. Um, Now, what Van Dyke did was situate what we're about to see in a theoretical context that would apply to any type of object, in his words, from cars to computers to sewing machines to software. It's just that people's brains don't turn off when you mention cars. I mean, they have enough background understanding of what a car is that they wouldn't be making these mistakes and they wouldn't have these silly regulations to deal with. Okay. Well, you let me know what you think about that in the comments. But okay. But at argument, and I saw the argument. I know what he's talking about. I watched the arguments on YouTube. At argument, it became clear to me that a visual illustration would greatly aid my colleagues and the parties in better grasping how this rather obvious conceptual problem specifically applies to firearms. So instead of straining to use written words to explain the many different parts of a gun and how each part could easily be deemed an accessory under the majority's vacuous test, I have decided to deliver part of my dissent in this case orally via video. under the established wisdom that showing is sometimes more effective than telling. Please click the link below and enjoy the presentation. Okay. All right. Now, if we click this linky winky, it will go to the, now I want to, let's, hold on. Let me just exit out of this. I'm not really sure why it's not going directly to the fitness industry. Okay, oh sorry, this is an ad. I gotcha. Okay. Gotcha. Huh. Oh, you know what I should have done? Sorry. I'm sorry. I should have opened this up in a new tab. I apologize for that. That's my mistake. I don't know why are there ads running on the Ninth Circuit YouTube? Are they making money on this? Are they monetized? Come on, guys. All right. There we go. That's what I wanted. Gosh, these freaking. Now, I want you to see that this is the United States Court of Appeals YouTube. You see that? Let's click. Okay. Sorry about the sound. This is the United States Court of Appeals for the Ninth Circuit YouTube channel. It says this is the official YouTube channel for the U.S. Court of Appeals for the Ninth Circuit. Oh, they have a Twitter account. Wow. Look at all these subscribers, 15,000 videos. Jeez. Wow. Okay, so this is an official government. And this is part of the dissent. Okay? This video you're about to see is part of the dissent. We're going to make a fair use of this transformative reading. However, I want you to notice this is not copyrighted. We're going to use fair use anyway, but there's no copyright on this video. This is part of a public domain dissent. So this is Judge Van Dyke in his chambers there. Let's take a look at the data. This has almost 300,000 views. It was published on March 20th, 2025. No description has been added to this video. It's on the Ninth Circuit, so somehow this guy got this sucker on the Ninth Circuit. The video is titled Dissent Video in 23-55805 Duncan versus Bonta. So it is an official part of the en banc record in this case. It's a dissent. It's part of the dissent. It's 18 minutes long. Comments are turned off. Shocker. Shocker. And let me make sure that original sound for musicians is on. Okay, good. Because otherwise you might not be able to hear it. I don't know. But I want to thank the Ninth Circuit for making this material available. We appreciate the Ninth Circuit Court of Appeals for making this material available. Of course, they're doing so because they have an obligation to under law, but we thank them anyway. We thank Judge Van Dyke for writing this. Thank you, Judge Van Dyke, and thank you to the whatever staff helped put this on there. So let's see what Judge Van Dyke has to say.
I'm Judge Van Dyke, and welcome to my chambers. I'm making this video as part of my opinion in the Duncan v. Bonta case. In this case, the state of California made the argument, which the majority has now accepted, that a magazine holding more than 10 rounds is just an accessory, not an arm protected by the Second Amendment's right of the people to keep and bear arms. I think anyone with a basic familiarity with firearms could show you that this attempted distinction is simply inconsistent with reality. I alluded to this during oral argument when I asked California's counsel about the balance of the tests that are proposed for what qualifies as an arm protected by the Second Amendment. Let's go to that exchange now.
Magazine and
Can I ask you a question about that? Because
yes, Your Honor.
So the way you're treating magazines, it seems like you could use the same sort of
One of these kids is doing his own thing. One of these kids is not the same. Oh, sorry. Am I not sharing my screen? Jeez. My goodness. I don't know how much of that you missed. Sorry.
Hi, I'm Judge Van Dyke, and welcome to my chambers. I'm making this video as part of my opinion in the Duncan v. Bonta case. In this case, the state of California made the argument, which the majority has now accepted, that a magazine holding more than 10 rounds is just an accessory, not an arm protected by the Second Amendment's right of the people to keep and bear arms. I think anyone with a basic familiarity with firearms could show you that this attempted distinction is simply inconsistent with reality. I alluded to this during oral argument when I asked California's counsel about the balance of the tests that are proposed for what qualifies as an arm protected by the Second Amendment. Let's go to that exchange now.
Magazine.
All right, so he's there in his chambers in Reno, Nevada, I believe. And this is the oral argument. One of these kids is doing his own thing. One of these kids is not the same. This is the attorney. And I think this is the attorney working for California. So for the Democrats, okay? And there's Judge Van Dyke right there in the top right. So these are all judges, and this lady here is also a judge. She's in her chambers for some reason, probably because of travel or something like that. So he's saying this is part of his dissent, the back and forth here. Check it out.
Can I ask you a question about that? Because
yes, Your Honor.
So the way you're treating magazines, it seems like you could use the same sort of rationale as between a non-semi-automatic firearm, say a lever action or a bolt action or a revolver type action, and a semi-automatic firearm. So I'm trying to figure out if you're saying, well, what we do is we say, have people ever banned particularly dangerous rounds? And now we're saying large capacity magazines are particularly dangerous. Why couldn't that same reasoning be used to ban semi-automatic firearms altogether? To say, because I mean, think about it, like during the Revolutionary War, if the United States had semi-automatic firearms that only held 5 to 10 rounds.
Could we use your house to trial our 24-hour bathroom upgrade system? We're looking for homeowners within valid states to test our new 24-hour...
Oh, sorry about that. I am so frustrated with these ads. My gosh, you guys should stop. Just stop. Stop with the ads. My God. Just stop with the ads, YouTube. What the hell? Seriously, I'm trying to concentrate. Gosh. Let me go off on YouTube for a sec here. This is the Ninth Circuit. You're making money on the... It's the government. It's a federal government. What kind of monetization do they have? What are you doing running ads like that? It's just unbelievable to me. There's so many ads on YouTube now. You can't go more than 2 minutes with a damn ad coming in your face, and you're concentrating, and of course you know why they're doing that. They want you to have a subscription to premium. Yes, premium. Oh, yes. Premium, where we don't distract you every 2 seconds. All right. Let's try that again. Did you guys catch what he was saying? He was saying, if your premises are correct, that would mean that you could ban virtually everything. Everything. Except something that's useless as a firearm. Let's take a look.
It would have been over, right, as against muskets. So clearly, the semi-automatic mechanism is way, 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 way more particularly dangerous than the difference, the delta between a 10-round magazine and a 15-round magazine. So why does your reasoning not mean that, if this reasoning works, why does your reasoning not mean that a state could just ban the semi-automatic firearms altogether?
So if we're just start talking, Your Honor, about this initial sort of textual question, I think if you're dealing with a semi-automatic, that would fit the definition of an arm.
No, but that semi-automatic could be a revolver. Like it could be, I mean, just like this, that high capacity magazine could be a lower capacity magazine.
Right, Your Honor. So I think that would fit the definition of arm, and then you'd move on to the other aspects of the Bruin analysis. At stage one, is a particular weapon that's being addressed by the law in the tradition of dangerous and unusual? Is it in common use for self-defense? And we think Heller is clear that has to consider the character as well.
I'm not understanding your, I think I'm missing your response to my, it seems to me that just as you could say, are you saying that yes, so it would be an arm under, you're not conceding that it would be an arm under stage one. So why are you saying it wouldn't be an arm, but the semi-automatic versus revolver, say, distinction is something that we're stuck with? I mean, you would agree that you can't ban the automatic mechanism.
Well, an automatic mechanism, I think that you can ban. I think the Supreme Court has recognized
No, the automatic mechanism is a term that semi-autos and full autos use an automatic mechanism.
Sure, Your Honor. I'm sorry for the confusion. No, I don't think that we could ban all semi-automatic weapons. I think Heller makes that clear. The point I was just making is, with respect to accessories, I think we have a difference of opinion where my friends suggest any accessory that is somehow helpful to armed self-defense.
So that's important, because your argument turns on whether you can characterize accessory. So you would say that the revolver versus semi-automatic is not an accessory, but that a magazine is this accessory. So what would you think about like a red dot sight, electro-optics, which many firearms are going to electronic optics nowadays. They're obviously an accessory because you could have iron sights. Could you ban those?
Well, so, Your Honor, I'm not intimately familiar with that, and I do want to answer this question and make sure that I save time for rebuttal. I think that the question at the outset would be, is that, if it's an accessory, is it within the Teixeira principle that it's necessary to the realization of the right to self-defense? And you'd have to build a record and analyze it in that case.
So, counsel, you're saying...
Now, from this exchange, it became clear to me that many, including both California's counsel and my colleagues in the majority in this case, lack the basic familiarity with firearms to understand the inherent shortcomings and obvious inadmissibility of the test that California was proposing.
Okay, I'm going to pause it right now. No, I don't want a quick note. Quit trying to guess what I want. Jeez. Sorry, this is me yelling at my computer. Did you guys catch that? I don't think that Judge Van Dyke did the best job on the Q&A. Okay, I'm just going to say that. That wasn't particularly enlightening. Some of you are probably stuck on the revolver semi-auto thing that he said. I think what he's saying is, if you define semi-auto as with each pull of the trigger in a double action revolver. Okay, if you define semi-auto as with each pull of the trigger, a new bullet goes into a position where it can be fired and will be fired. Okay, if you define a semi-auto that way, then a double action revolver would cycle. The difference is that each charging hole, I think is the technical word for the hole in the revolver that holds the 6 bullets or however many bullets there are, is its own chamber. And so you have as many chambers as you have bullets. Whereas when we typically talk about semi-automatics, there's one chamber and the magazine feeds the bullets into that one chamber with each pull of the trigger until it runs out of ammunition. Okay, so I think the term automatic mechanism might be a little bit unfamiliar to people. If you look at old descriptions of Colts, for example, the original Colts, which are semi-automatic. The pistols I'm talking about, like, for example, the 1903 pocket hammerless, the 1908 pocket hammerless, the 1911, the very old, these are over 100 years old designs for semi-automatic pistols that were issued to the United States Army. I mean, these are weapons of war, military style. They're not military style. They're military weapons. They're weapons of war that were semi-automatic, but they were called Colt automatics. And I have, I've held in my hand some of these when I go to the auctions, and you can pick them up and you can look at the boxes and you can look at the original packing materials and the brochures that go with them and stuff. They call them Colt automatics. And so that it's a very old term for a semi-automatic weapon. And I think that might have been over the heads of people. And even some gun nerds are probably like, hey, that's not what, but everything he's saying can be understood, okay, as not incorrect. But I think to try to squeeze all that into a Q&A, I think what he was trying to say is, doesn't it reduce to absurdity this definition of accessory where some magazines, the ones you like, are essential pieces, they're actually arms and protectable by the Second Amendment, and the ones you don't like are accessories. That's what he should have nailed on. The accessory issue, when you start talking about red dots, can you ban those? The problem is it's not really a reductio ad absurdum to ban accessories, because there are all sorts of restrictions on accessories, and that's not as clear as I think he was really going for. I think I want to go get some. I want to get some speakers because I want you to hear this. It's a little quiet on my end. I'm not sure. I think it's the original video, but I think it's really quiet. I can't hardly hear the guy, and I'm kind of worried about my Apple audio only people. They're probably really frustrated with this one, but we'll do the best we can. We have to cover this material, so we're gonna press through.
Recording in progress.
Okay, sorry about that. We have Judge Bumate. I'm going to share my screen again. Feel free to call me Sharon. Let's go.
Accessory, is it within the Teixeira principle that it's necessary to the realization of the right to self-defense? And you'd have to build a record and analyze it in that case.
So, counsel, you're saying?
Now, from this exchange, it became clear to me that many, including both California's counsel and my colleagues in the majority in this case, lacked the basic familiarity with firearms to understand the inherent shortcomings and obvious inadmissibility of the test that California was proposing, and which the majority in this case has now adopted. I originally planned to explain all of this in writing, in my opinion, and why the argument doesn't make sense, but it occurred to me that in this instance, showing is much more effective than telling. As the old saying goes, a picture is sometimes worth 1,000 words, and here I hope you will agree that a video is at least worth that much. And I suppose at this point in the video is as good a time as any to apologize for any shortcomings of the video. This is the first video like this that I've ever made, and in our digital age, I fear that people have become accustomed to a production quality that I'm sure that I fall far short of. But I hope and expect that regardless of...
Well, you're not alone there, Judge Van Dyke. We're over here recording on Zoom, and I can't even, get rid of the ads, that I'm just trying to share this stuff. But anyway, we appreciate the Ninth Circuit for making this available and for permission to use this clip. Thank you.
Such flaws, this video will still powerfully serve the purpose for which I've made it. I also want to emphasize that for safety purposes, I have rendered inoperable all the guns and gun parts that I use to demonstrate today. And finally, as an appellate body, it's obviously not our role to make factual determinations, so I share this not to supplement the factual record that we're using to decide this case. Instead, I share this because a rudimentary understanding of how guns are made, sold, used, and commonly modified makes obvious why California's proposed test and the one my colleagues are adopting today simply does not work.
Okay, that's a key point. Did you guys catch that? That's a very key point. Let me go back.
And finally, As an appellate body, it's obviously not our role to make factual determinations, so I share this not to supplement the factual record.
Okay, that's the key part right there that saved what he was doing here. That part right there. He was criticized for introducing new evidence as a judge, which is totally inappropriate. But he said in writing and in the video that that's not what he's doing. So the question becomes, do you believe him? Does it make sense that that's true? I think what he's saying here is he's saying this link to this video, which goes to YouTube for some reason. I don't know. Here's the web address, https www.ca9.uscourts.gov /media/23-55805/opinion. That's a Ninth Circuit website. But when you click on it, it goes to YouTube, which is a private company. I mean, I'll click on it again. You can see. Open up in new tab. It goes to, and now there's a daggum ad. I'm sorry about this. I can't skip them fast enough. It goes to the Dissent, which we're in. I'm going to X out of that since we were at minute 5:05. So minute 5:05, he says that he's not supplementing the record here. This is very clunky, I think, but this might be my most hopeful interpretation of what's going on here is this Hail Mary that he's doing might be caught in the end zone. And this is Elway going to Steve Watson. And my dad loved Steve Watson because he was the one that didn't, number 81, Denver Broncos, he did not go on strike when everybody else went on strike. And so, we stopped watching the Broncos when they went on strike because my dad was like, no, these guys, they don't go on strike. That's not what you do as a professional football player. But anyway, I digress.
That we're using to decide this case.
Remember, this is Judge Van Dyke, Trump appointee to the Ninth Circuit. This is the official video. This is officially part of the record of the Ninth Circuit dissent, the opinion of the court in the en banc case, the record of that rendering, the final product that the court put out.
And I share this because a rudimentary understanding of how guns are made, sold, used, and commonly modified makes obvious why California's proposed test and the one my colleagues are adopting today simply does not work. I'm sure I could explain all of this in writing without being accused of improper fact-finding, but it's obviously much more effective to simply show you. So let's do that now.
Wix. One platform.
Sorry.
Any website.
Sorry.
To demonstrate, I'm going to start with this SIG P320 that's basically in its stock configuration. That is, this gun is basically in the same configuration it would come to you from the manufacturer and be sold to you at a retailer. This is one of the most popular handguns currently on the market in the United States. And so I'm going to use this to point out some of the essential parts of a handgun. These same parts would exist on pretty much every handgun, at least of this semi-automatic type. So let me start by pointing out a few of them. This one comes with a standard 21-round magazine.
Okay. You see what's going on here? He's in his chambers at the Ninth Circuit.
Comes from factory just like that. You can buy a similar...
And these are his guns. He just put a magazine and it was sticking way out of the bottom. He just put a magazine in his own gun. So...
version that comes with a 17-round magazine that fits flush.
He just put another magazine.
Comes with 21 or 17-round magazine. It has a standard full-size grip. It has a factory trigger, which has a pull weight of about 7 pounds or so. Has front and rear iron sights that are used to aim the firearm. It has this little takedown lever, which is small, and you may have trouble seeing it, but we're going to talk about that some later, and that's what you use to remove the slide and disassemble the firearm. And the entire gun is designed around the automatic cycling mechanism. That is, when you pull the trigger and fire a round, right when that happens, it automatically will rack the slide back, eject the round, the spent cartridge out of the gun. It will grab a new round out of the magazine, put that round into the chamber, into the barrel, and it'll be ready to fire another round the next time you pull the trigger. So this is a semi-automatic firearm. Now, I want to use this handgun to illustrate first California and the majority's argument as applied to this obviously typical and very common handgun. And then,
okay, for those of you listening on audio only, I'm going to describe the table. He has two firearms on the table. He's got a revolver and he's got another semi-automatic pistol with looks like a red dot on top of it. And then he's got an assortment of magazines, and he's got a bag. It looks like a tote bag, and it's got some kind of emblem. It might be the Ninth Circuit emblem. I'm not sure. Otherwise, it's a pretty boring looking office. Actually, there looks like is that a gun cabinet back there? That couldn't be. No, that's not a gun cabinet. What am I thinking? That's I'm sorry. I just said something dumb. I was looking, there is some kind of cabinet, but it doesn't look like a file cabinet. And it does kind of look like there's like a shotgun or something standing next to it, but I don't think that can't be what it is. He's got a painting, he's got a map. Looks like it might be of California, Nevada. But otherwise, it's just him alone, and it's not clear if there's anybody else in there, like a clerk. What does that clerk think of this? And he's got these guns in there. Okay. So I just had to, continue. Let's continue.
Then I want to show you that the same argument would apply to other parts of the firearm and to this firearm as a whole. Now, as a reminder, California's argument, which the majority has adopted here, is that a magazine that holds more than 10 rounds is not an arm protected by the Second Amendment. So this 21-round magazine that comes from the factory or a 17-round magazine is not an arm protected by the Second Amendment. Now, California acknowledges that a magazine is necessary to make the firearm function, but they argue that because you can replace the standard magazine with one that holds fewer rounds, 10 rounds or less, then these higher capacity magazines are not an arm and thus wholly unprotected by the Second Amendment. Now, the problem with California's argument is that, as I pointed out in oral argument, the exact same argument would apply to essentially every part on this firearm, which would mean that essentially nothing on this firearm would be protected by the Second Amendment. Allow me to illustrate that using this firearm. Now, in oral argument, I asked California's counsel if their argument meant that the sights on this firearm are not protected by the Second Amendment. And part of the reason I'm making this video is because it didn't appear that counsel understood what I was asking. So take a look at
that's a really key part right there. That's a really key part. That's part of his claim that he's not introducing new evidence. Part of his claim that he's not introducing new evidence, which is totally inappropriate for a judge. He's claiming this is appropriately a part of his dissenting opinion. Right? Remember, I just showed you that the Ninth Circuit, this web address goes not to a government website, but to a private company, YouTube, the government YouTube channel on the private company. If you can make sense of this, good for you, man. Because I'm like, my mind is kind of bending, but I guess it, the president goes on Twitter and, I think it's kind of scary that government is using private. What the government is saying to us is mediated by private companies. I think that there's something creepy about that, because YouTube could shut this down and then you'd lose this record. And gee, what is the political orientation of YouTube, a private company? It's Democrat. They're Democrats, right? Now, I'm pretty nervous about private companies mediating what government officials say, and you can't get it directly. It's one thing to, I guess that happens on television and stuff like that, but and newspapers, that's what media is. That's the very idea of media. It's mediating something. I just worry about the records. Like, where do you go for the records? Do people know that? Do people know? I mean, we go to Google Scholar for the records that we use in this podcast quite a bit. But all right, I'm gonna quit bloviating about that. We're gonna go back to what Judge Van Dyke is saying. Okay, I'll put a link I'll put a link to this decision, this dissent, in the description, and that PDF itself will have a link to the video, as you'll see. So I'll just put one link in. Okay.
Handgun. What you see on here are iron sights. You have a front and a rear iron sight. And the way that you fire this handgun, the way you aim it, is you take and you line up these two sights and you line them up on what you want to shoot at.
Okay, so what I'm seeing here is a judge in black robes in his chambers with a gun as if he was a cop. And it looks like he's about to shoot something. But he said he's already rendered them inoperable and they're unloaded, so... But that's what you're seeing on the Ninth Circuit. And so that's what people are freaking out about. That's why they turned off the comments. This is the dissent video in 23-55805 Duncan versus Bonta, United States Court of Appeals for the Ninth Circuit. I have my cursor over that so it's picking up the entire text. You can subscribe. No comments. It was published on March 20th, 2025. No likes.
And that's how you hit what you're aiming at with this firearm. These are iron sights. They're probably the most common sighting system for a handgun. But all you have to do on this particular handgun to change out the sights is remove two screws in this slide right here, and the back sight comes off. And when you do that, you can put the two screws back into a red dot optic, and now you will have a firearm that instead of having iron sights would have a red dot optic. Let me illustrate that by just taking a slide where I've already installed the red dot optic. And
okay, so he's changing a slide. All he did was he took the slide off the first gun, and he took the slide off the second gun, I guess, and he switched them. So there's now a red dot on the first gun he had in his hand, and before there wasn't one. And that appears to be the only difference. There are some differences. It's a totally different slide though. So he just switched slides. We're at minute 9:03.
Here you go. See, so now you have this back iron sight's been taken off, and here's a red dot optic. Now, in the hands of an experienced shooter, this red dot optic allows you to shoot the firearm more quickly, to get on target more quickly, to hit what you're aiming at, be more.
I'm laughing because I can see the meltdown. People are freaking out. What are you talking about? You have a red dot? It makes you hit what you're aiming at? Well, I mean, those of us in the Second Amendment community were used to this because in a self-defense situation, which is a paradigmatically innocent conduct under the law, you do, if it is self-defense, you want to hit at what you're aiming at because that protects innocent bystanders. So this is all in service of exercising the right lawfully.
Accurate, and so it's obviously much more dangerous if it's being used for an unlawful or wrong purpose. But if it's being used for a lawful purpose, then it makes the firearm better for that intended purpose. So this firearm would be better for self-defense or competition, recreational shooting, or hunting. And indeed, my own self-defense handgun.
I don't know why you would be using that particular firearm for hunting. It's kind of a faux pas, but okay.
Which this is another P320 that's been configured slightly differently, has a red dot optic precisely because it makes the firearm better for its intended purpose.
Did he just say that that was his self-defense one?
Or competition.
Okay, so he's got one, and he's about to pick up another
recreational shooting or hunting. And indeed, my own self-defense handgun, which this is another P320 that's been configured slightly differently.
Okay, so he just picked up a smaller one, and he said this is the one he uses for self-defense. That's the one he's packing.
It's a red dot optic precisely because it makes the firearm better for its intended purpose, that is self-defense. It makes it more accurate more quickly and shoot more quickly. Now, so in that sense, this red dot optic is just like this magazine. It makes the firearm more dangerous when it's misused, but it also makes the firearm work better for its intended purpose when it's used properly.
Well, I'll say this. I don't like the term I don't like the term...
hey, everyone.
Sorry, this is another ad. I caught it just in time. Let me... Sorry about that.
That's
man, I'm serious. This is so hard. This is one of the hardest episodes I've done. Just, it's hard. It's hard, man. Trying to give you guys the good content, and I don't like using that term content. I hate that word, content. I'm just trying to give you guys some legit stuff here. This guy is a freaking federal judge. He's got a gun in his hand in his chambers. That alone is like front page material. But he actually seems to know what he's talking about. I mean, he kind of reminds me of Rain Man up there. He's like, yeah, this blah blah blah. You know, there's 496. You know, and there's gonna be people that be like, no, he's not Rain Man. There's 4 left in the box. Well, what it says 500 on the box, you idiot. Anyway, okay.
Intuitive about the sighting system for a firearm, but the same thing is true about basically every part of this gun. Let's take a look at a part that's maybe a little less intuitive, which is that takedown lever that I talked about earlier.
Yeah.
This little piece here,
takedown lever.
It's necessary for the operation of the firearm. It's a tiny little piece that you need to have for the firearm. And so you would think, well, since it's necessary, then it must be an arm protected by the Second Amendment.
Necessary.
But not under California's logic in this case. See, you can replace this factory takedown lever with a different factory takedown lever. This one's called a gas pedal. And when you do that, you replace it,
a gas
put
pedal.
the slide back on.
We're on minute 10:57, 10 minutes and 57 seconds out of a 18-minute and 44-second video.
Now the firearm is a lot more controllable under recoil. You can, just like with the red dot sight, you can do faster follow-up shots. You can aim the gun more quickly, and you can control it better. So again, as with the red dot sight, as with the higher capacity magazine, this particular takedown lever makes the gun more dangerous when it's misused, but also makes the gun more effective for its intended purpose when it's used properly.
Yeah.
So under California's logic, because this is an accessory, this little takedown lever, it could be replaced with a worse part. This little takedown lever is not protected. It's not part of the arm protected by the Second Amendment. Well, you might ask yourself, well, what about the grip? Like, you think this grip, certainly it must be part of the arm. I mean, it seems like that's a pretty key part of a firearm, is the grip of a pistol. Well, actually, under the majority's argument, it would not be protected. And the reason is, here's a bunch of grips that I accumulated over the years. I'm just going to pull a couple.
Okay, I have to narrate this for those listening on audio only. He just dumped out the bag that was on the table, the tote bag, and all this crap came out. All this, like, it looked like a bunch of guns came out, but they're actually not guns. They're 1, 2, 3, 4, 5, 6, maybe. I can't tell. I'm losing track of, but they look like they're semi-autos without the slides and without magazines. Okay, so it'd be like the lower part of a Glock. They don't appear to be Glocks, though. I mean, one looks like it's a Glock. Maybe 2 are Glocks, but And then he's still got the revolver. We're wondering what he's going to do with that. He's still got some magazines, and he's holding up two, I guess. Why am I blanking here? Just it's the pistol without the slide. Okay. It's missing the slide, and it's missing the magazine. So he's got two of them in his hands.
Nice small grip, a nice small light grip. This is a big heavy grip. So what you can do on this firearm is you can remove the slide, remove that takedown lever, take what's called the fire control unit out of the firearm. This is actually the firearm under the...
Okay, he's holding up what he says is actually the firearm, and it's a tiny little piece. I have, blown this video up as much as I can. I mean, the picture, so you can see, but it's still very small. He's holding it with two hands, but it's very small. You could easily hold it in one palm of your hand. It's just a metal thing. It looks like it has a trigger protruding from the bottom. And he says that's what the firearm is. According to California, that's the firearm. That's the only thing you can't ban under their premises. And he's saying that's what the reductio ad absurdum is. This is an absurd result, therefore there must be a problem somewhere in their premises. And he didn't say it as clear as that, but that's what he's saying. That's what he's saying there. So
move the slide.
Okay, so we're at minute 12, 15 or so.
Remove that takedown lever. Take what's called the fire control unit out of the firearm. This is actually the firearm under the ATF's definition. And you can take this fire control lever and you can put it inside this smaller grip. And you could use this grip for, say, self-defense purposes.
Okay, he's putting it in a different lower housing unit, basically, that would house the, it's got the grip, and it would receive the slide and the trigger and all that. It's got the trigger guard, but it doesn't have a trigger in it.
Because it's very concealable, it's light, it's easy to carry, and indeed, you'll see that's pretty much the type of grip that I have on my self-defense firearm. Or you could take this much heavier grip with aggressive stippling on it and with a flared mag well, and you could put this fire control unit in there.
I'm laughing because I just have to remind you that this is part of the dissenting opinion in this Ninth Circuit case. He's talking about flared magwells, and he's dumping out his Trader Joe's bag or whatever full of it. I'm having a great time, man. I don't know if you are.
Put the takedown lever on, and then you put the slide back on, and now you have a firearm that is much better at being able to take quick follow-up shots, hit what you're aiming at. And so this grip, all of these grips under the majority in California's logic could be banned because if they were misused, they would make the firearm more dangerous, and you could put a different type of grip on if you wanted to.
And Judge Van Dyke, and what? And that's absurd. You got to say that. That's the absurd result. So, in a reductio ad absurdum, you're required. You are permitted, but because required includes permitted, a duty includes a right. You have an epistemic duty to go back and figure out what the problem was. And so I think he could have used a little bit of, coaching on that, but he's doing a good job.
So you might ask yourself, well, what part of this pistol would be protected as an arm under the majority?
Yeah, this is the key part right there.
Well, I suppose California would eventually be forced to say, well, this part, the FCU, I guess, is the arm protected by the Second Amendment. Every other part that you added, as I've just shown you, every other part that you added could easily be characterized, just like the magazine, as an accessory that you add to the firearm,
yeah.
And therefore could be banned under the Second Amendment. But
And that's absurd. You got to add that part, because if you don't, then it's off to the races. I think he's doing a decent job, but I think it would have helped. This feels a little bit rushed to me, but
not so fast. Even this part, the FCU, the core basic part of the firearm, could be banned under the majority's rationale. And the reason is, let me show you another FCU. This is the FCU for my competition gun. It has a really nice trigger, a nice light, crisp trigger.
My competition gun. He's holding up a different fire control unit with a different color trigger. It's blue. And man, he looks like such a gun nerd right now. It's funny.
And has some parts replaced in here. It makes for a really nice trigger.
Yeah.
You can upgrade the trigger to make it much nicer. And so
much
because
nicer.
of that, under the majority's logic, you could even ban this FCU, or at least most of it, as simply an accessory under the...
Judge, why didn't you bring this stuff out during oral argument? Now that would have been a viral video.
And now protected by the Second Amendment.
This one mistake is stopped.
Sorry, guys. I'm trying to protect you guys from these ads. Seriously, guys. Sorry. I have to wait the 10 seconds or whatever and then skip. Jeez. Man, so frustrating. I know. It's a pleasure. It's a pleasure. Are you with me? Okay. We're recording. Good. Every time I get an ad, I get so thrown off here. Jeez.
So what I've shown you could, I suppose, be conceptualized as upgrades. You say, well, that's an upgraded trigger, and that's an upgraded takedown lever, and that's an upgraded grip.
Upgraded, yeah.
But the majority's logic works both ways. I've just shown you how you could easily improve the sights, how you could easily improve the takedown lever, you can improve the grip and the trigger, you could do the same thing with the barrel. But you could...
The entire time he's talking, he's monkeying with his guns. I mean, he's just talking, and I mean, it's like I'm watching Hitchcock 45.
Easily downgrade all of these factory parts of the handgun to make the firearm less accurate and slower. You could put in worse than factory trigger. You could require worse sights than what it comes with from the factory. You could require a grip be put on that hurts the speed and accuracy. Indeed, this type of downgrade is precisely what the majority is actually requiring in this case. As we mentioned earlier, this comes from the factory with a 21-round magazine, or it comes with a 17-round magazine in a slightly different configuration. But the majority is requiring that these factory standard parts be replaced with worse than factory parts, a 10-round magazine. So when we take everything off that the majority might call it accessory, what we're left with, at best, is this fire control unit. And as I've explained, even that could be dumbed down so that much of this fire control unit would be an accessory under California's argument. And of course, you can't shoot this, right? It's inoperable.
Right.
You need all the other accessories that I've been describing in order to make this work as a firearm.
Yeah.
But of course, also each...
Yeah, right. Let's dig into that point here. You can't. This is maddening, because he's holding up what would be the essence of the term firearm under California's understanding of it, but you can't shoot it. What about that? I mean, isn't that a reduction to absurdity, that the definition the government has of a firearm is not even something that you can shoot, which would seem to be what a firearm is? Am I wrong, or am I right, or am I right, or am I right, or am I right? You know what I mean, Vern? We're almost done with this video. It's at 1601 out of 1844.
To these other pieces.
Again, United States Court of Appeals for the Ninth Circuit. We like to thank the Ninth Circuit for making this available. Of course, they're not doing it for profit. It's a nonprofit. It's government. And they have an obligation to publish this. So they're not doing it because they like you and they're trying to help. They're doing it because under the law they're required to. And again, this is not copyrighted information. You guys, this is This is in the public domain. Okay, so let's keep going. This is Judge Van Dyke in his chambers. Minute 1603, dissent video, and 23-55805, Duncan versus Bonta.
Just like this magazine, could in some way be considered an accessory, since they could be replaced with a different part that would be less useful and make the gun less dangerous if misused. And that could be said for pretty much every single part of this handgun. And the same problem with the majority's argument applies to other aspects of the firearm that are less easily shown in the video, including fundamental aspects of how this firearm operates. At oral argument, I asked California's counsel why California couldn't ban the automatic cycling mechanism altogether under the California's argument. And again, I don't think he understood what I was talking about.
No.
Well, this handgun uses that mechanism.
No,
this uses the automatic cycling mechanism. And this semi-automatic auto-loading operation is the most popular mechanism that exists today and is used for self-defense. But other mechanisms exist for handguns, including probably most obviously the revolver mechanism. Here's a revolver. Think of the 6-shooter from...
Okay, he's got the revolver in his hands now. Yay. He's got all this. This is classic, man.
The old Western movies, right? You can have a revolver, which is not automatic.
He's got it looks like he's got a Ruger single 6 or something. It's one of those Rugers.
Or you could, and there's different types of revolvers. There's single shots, there's double actions. You could have the lever action, you could have a pump action, you could have a single shot break action, which only has one round. You have to open it up and manually take the round out and put another in. And under California's argument, because any of these single types of mechanisms are not essential to make this handgun work, and thus, or make a handgun work, and thus are not an arm under the Second Amendment, California could ban the whole semi-automatic mechanism altogether, thereby effectively banning semi-automatic handguns altogether, forcing everyone to use revolvers or single-shot handguns or worse. Okay. And of course, with bad sights, crazy heavy trigger pulls, a terrible grip, you get the point. Right. Ultimately, California's argument, which the majority has unwisely adopted here, is based on the unstated assumption that there's some basic, I guess, unadorned, without any accessories firearm that would be protected as an arm under the text of the Second Amendment, but everything else is merely an unprotected accessory that's been added to that firearm that's unprotected. And I hope you can tell from this video that that idea is simply unrealistic. It could never be applied in real life. Like many of this court's ideas about the Second Amendment, it stems from a basic misunderstanding of how firearms work, combined with a highly unrealistic idea of how such a rule would be administered in real life.
Right. And so that's why he's doing this, is because the minimum required background knowledge, even to understand the record, is missing, or it's got holes in it, and so he's trying to fill in those holes. I think it would have been helpful for him to say that.
Ultimately, the only rule that makes sense and comports with reality and the text of the Constitution is that the entire handgun here, including the grip, this takedown lever, the slide and barrel, the sighting system, and this magazine, are all part of the arm within the meaning of the Second Amendment. Thank you for watching.
All right, well, fair enough. Insofar as it goes, I'm going to go to the next. So remember, you just click on that link. They're supposed to go to www.ca9, the number 9, not the word 9, .us.gov/media/23-55805/opinion, and that goes to YouTube for some reason. It would be like, okay, well, I've already beaten that to death, but as I hope the video portion of this dissent helpfully illustrates, we're back on the text now portion of the dissent, coming back from the video, page 125. As I hope the video portion of this dissent helpfully illustrates, an arm, just like most other categories of objects known to the human experience, is a broad conceptual term covering an almost limitless variety of configurations within that category. Page 126 at the top. The majority does not and cannot dispute that. It acknowledges that the meaning of arms broadly includes nearly all weapons used for armed self-defense, but the majority nonetheless concludes that in its view, some parts of a firearm are necessary to the operation of a weapon and thus protected by the Second Amendment, while other parts are not necessary and therefore not protected arms. The majority then purports to apply its misguided new test to decide that higher capacity magazines are not arms, while lower capacity magazines are. All right. Let me see how much further we have to go before we finish. We might have to break this up into two different versions here, or two different episodes. It's quite long. It makes you wonder whether he really needed the video part of this dissent, because he goes on to write through page 147, and we're on 126. That's 20 pages left, and so we're going to stop there today. We have a pretty long episode as it is. So we like to thank the Ninth Circuit for making this material available, including the dissent video that we just watched, and of Judge Van Dyke. We'd like to thank Judge Van Dyke for writing it, and we will catch you on the flip side for the next in this series of
Hi, I'm Judge Van Dyke, and welcome to my chambers. I'm making this video as part of my opinion in the Duncan v. Bonta case.
Okay, so we have a Ninth Circuit judge that has made a video as a part of his opinion, an official record of the Ninth Circuit, at least as far as his dissent goes. And I've never heard of that before. Maybe it's been done before, but thanks for watching the Republican Professor podcast. Thanks for listening. If you were listening on audio only, you missed quite some entertainment there. You can go to the YouTube video and check it out. You can go, I'll have it linked, everything linked that you need to go to the YouTube. And we'll catch you next time.